Hello and welcome. Today, we're diving into the intricacies of court venue for trials in New Zealand. Where does a trial take place, and why? Let's break it down. Generally, an accused person is tried in the court closest to where the crime was allegedly committed. This isn't just a suggestion, it's the initial factual position. The law requires the Crown to lay the charge in the court nearest to the alleged crime scene. This is outlined in Section 14 of the Criminal Procedure Act 2011. This principle is rooted in the tradition that jurors should be drawn from the community where the crime occurred. Section 5(b) of the Juries Act 1981 reinforces this, stating that, as far as practicable, the jury should be drawn from the community where the alleged offense took place. Each city or town with a high court has a jury district, extending 45 kilometers from the courthouse. Jury summonses are issued to people residing within this district. But what if the trial venue needs to be changed? Section 322 of the Crimes Act 1961 allows a judge to change the trial venue if it's deemed expedient for the ends of justice. This is often considered in relation to Section 25(a) of the New Zealand Bill of Rights Act 1990, which guarantees the right to a fair and public hearing by an impartial court. It's not about proving a high threshold but rather persuading the judge that there's a real risk a fair and impartial jury cannot be impaneled at the current location. The risk must be genuine, not just illusory or fanciful. The judge has discretion in this matter, requiring an evaluative assessment. They must identify risks associated with the existing venue and consider ways to neutralize or minimize those risks. If the risks cannot be adequately addressed, the judge may change the trial venue. Several factors are considered when determining a change of venue application. The ultimate test is whether transferring the proceeding is in the interests of justice. A key consideration is whether there's a real risk that a fair and impartial trial may not be possible at the current location. Strong local prejudice can be a ground for a change of venue, but precautions taken during jury impanelment can sometimes mitigate this. Prejudicial information online generally doesn't support a change of venue, as it's accessible from anywhere. Ideally, the trial should take place where the offense was committed, and New Zealand jury research suggests that pre-trial publicity may be less significant than previously thought. In conclusion, determining the court location for a trial involves a careful balancing act. The law aims to ensure trials are held in the appropriate place, while also upholding the right to a fair and impartial hearing. Thank you for watching.